Kwamina, you can begin. Take over.
Can start now? We have about 2 minutes.
Yeah, we can start. It's fine.
Okay. So, welcome everyone to this evening's session of the lawyer's diary, where we will be discussing the procedures in acquiring lands in Ghana. We have with us today our guest speaker, Kwamina, lawyer Kwamina Mensah. I'll just do a brief introduction of our guest speaker, and then we would get right to it. So lawyer Kwamina Mensah is a managing partner at Dow's Legal Consults. It's a firm in Kumasi. He also serves as a board member and company secretary of Asante Kotoko Sporting Club. He is the author of the Annotated High Court Civil Procedure Rules 2004. And then he has co-authored 2 other books, The Lawyer's Companion, A Guide to Researching Ghanaian Case Law, and Company Law and Governance of Other Corporate Bodies in Ghana. Lawyer Kwamina Mensah, we are honored to have you here with us today.
Thank you so much, and good evening to everybody.
Great. We are excited to learn from you today, and we are excited to tap into your great knowledge. We know you have a lot of resources to share with us today.
It's none of you. Yes.
Great. So, guys, if you've logged in, once again, we are discussing the procedures in acquiring lands in Ghana. Basically looking at quite a few things that we had shared with you. We are looking at what you should know before you buy a land in Ghana. Most importantly, who you should know you are buying the land from, because that is also very critical when you are purchasing land in Ghana. We are looking at what your obligations are as a purchaser in a land transaction. We're also looking at, during the purchase, what documents that you must request from the seller when you are purchasing the land. We are looking at what you should look out for when you are doing the due diligence, because of course, you cannot just acquire the land, especially when you are buying land in Accra and Kumasi. When you don't do proper due diligence, you might find yourself wanted eventually when the true owner of the land comes and says that, no, I'm the one who owns the land. And so this person you could not have purchased the land from this person that you claimed you purchased the land from. Of course, land litigation is always ongoing in our courts. You find people fighting over the same piece of land. You find families fighting over the same piece of land. You find individuals fighting over the same piece of land. So knowing what to look out for when you're doing your due diligence, what your obligations are, and also what you must do as a purchaser after you have bought the land to protect your interests in the land is very, very fundamental. So if you're tuned in, we hope you would note your questions. The chat section is there. You can drop your questions in there as we are having a discussion, and then lawyer Kwamina Mensah would be honored enough to answer your questions as you drop in. After the session, we would also allow a few of you to ask some questions that you think maybe you may have in respect of the topic. So Kwamina Mensah, we are ready for you. And let's have you here once again. And we are ready to learn from you. So you can take over as our guest host.
As the French will say, merci beaucoup. And I'll say that first we have to know, for if issues about land, we have to know the nature of land or the type of land that we are talking about. So by doing that, we have to look at one, whether is it a stool land, is it a state land, is it a family land, or is it an individual who's bought a land and then you want to transfer it, or you want to work on it, or you want to give it to another person. So if we know the nature of the land that we are talking about, then we move from there and go to how we can acquire them. So we will take them one by one. What kind of lands that we have, the different types, the nature of land that we have, and then after that we can look at how the process you have to go through and certain nitty-gritties. So we look at state land. You know, we have state land that are lands that are vested in the states, and they can be acquired through the president making an executive order or instrument saying that you want to acquire certain portions of the land, or maybe certain lands have been given to the states by certain stools, and so we have different ways in which a state may get land. Even the state, because the state is a person, the state may also purchase the land. So we have different ones. Then we also come to stools. You know, those times stools use, or when I'm talking about stools, it also includes kings. I'm talking about chieftaincy. You know, those times there were a lot of wars, and through that they are able to conquer different areas, and because of that, stools now became owners of certain lands. And also, you know, certain after that, the indigenes, they also start working on the land. So, for example, maybe because I'm in Kumasi, I'll say that maybe Asante Kingdom, we go to a place called Ejisu. You know, after they have conquered the land, the indigenes start farming in those areas. And then because of that, they have also taken certain possession of certain aspects of those properties. So that once they are working on it over time, then they can say that, okay, this is my family land, or this is a family land. So now we can say that now it becomes a family property. Those times, some families, because of how great they are, maybe the stools won't even want to give them certain lands. So because of that, they also become owners of certain lands. Then we come to individuals. You know, individuals, even though they are not families, but they can also be granted certain lands. They may also buy the land from different people, maybe stools. They may buy it from the states. They may buy it, so that we have also individual ownership. So that before anybody wants to get any land, you have to understand what land am I dealing with. So that if you know the nature of land you are dealing with, then you can also say that, okay, this is the procedure we have to follow in order to acquire it. So that having determined how you can get the land, then let's look at the various stages. Let's say, for example, if it's a stool land, how will you be able to acquire them? If it's a family land, how will you be able to acquire them? You know, usually the stools, we call them usually stools. When they conquer areas, we call them in law allodial title holders. But you know, we are not going to so much into laws and those kind of things. So we just want to make it a little simple. But we call them allodial titles. Once they have conquered certain areas, then they become the allodial title holders of the land. Then the individual indigenes, they own something we call freehold interest because of the farming or those activities they have on it. And you know, those same people, like the stools or the families, they can also lease, or they can also give out those lands to different people. I can, because I'm from a different area, when I come to Kumasi, maybe they can lease the property to me for maybe a certain number of years. And so when it comes to a stool property, before you can acquire it, then you have to know that you have to get the chief or the occupants at that time, or either the regent. So it is important to know who the regent or the chief is at that time. So that if you go there, the chief alone cannot be able to give you the land or cannot be able to sell the land to you. He must be able to do it with his or her elders. So if it's maybe some properties are under women or him, or maybe different persons. So because of that, we can say that if it's a lady, then those one we call it, maybe in our local setting here we call it on him. So you go to that person and then you go to the occupants, and then together with the various elders of that stool, then they'll be able to give you they'll be able to sell the land to you. And when it comes to family too, we have to also know that family is only the head of family together with the principal members. You know, when you talk about principal members of the family, we are talking about certain important members of the family. You know, when you go to every family, there are certain people that when issues come in, they will call that, oh, these are the people that they have to go to. So those are the principal members of the family. So that it's only those people that you can go to give you the land. And they say the family, we have to know which kind of family you are dealing with. In Ghana, we have two types of family, the patrilineal and the matrilineal system of family. The matrilineal is where, you know, they inherit through their mothers or through the women in the family. And the patrilineal is through the men, as through the fathers or uncles and the grandfathers. So that if you know which kind of family you are entering to, then it will also help you. Usually around the Akan areas, they are predominantly matrilineal. But when you go to the Volta, most parts of the Volta, and also some parts of Accra or Greater Accra, they also practice the patrilineal. And Northern region too, they mostly practice also patrilineal. So that in those circumstances, then we have to know that if before I buy the land, which kind of family is giving me the land is also very, very important. And then having done that, then we will continue, and then we say that, okay, now I've identified the particular family that maybe is patrilineal or matrilineal. Then the next question you have to ask, who is the head of family of that area? So if you of that family, if you know the head of family, then you also have to ask for the principal members of that family. As I told you about the principal members, they are the important people. They are the important people in the family that we normally have to go to when maybe there are some issues, and then they will be the ones to come together to sell the property to you. The head of family, or if it's a stool, the stool alone cannot just give you the land. The chief alone cannot give you the land. It's not proper. And also the stool, the head of family alone can also not give you the land. He has to also make sure that he does it with other people. It's very important. But not doing that alone per se. Not if a head of family or a stool per se, the chief doesn't give it together with the elders. It does not necessarily mean that the land you have acquired itself is not proper. But just that, as long as the family can challenge, if it's a family property, the family can challenge it that the head of family has not done it with the consent and the concurrence of the family, or if it's a stool that they have not done it together with that. So for you to buy a land, you have to actually know how to go about it. So you have to identify, as we learned first, what type of family, what type of land am I coming to? Then secondly, after that, then we can know who are supposed to give the go-ahead for the land to be sold. Then having considered that, the very important thing for you to look at is that usually it is prudent for you to do a search as the Lands Commission. The search is to show maybe a particular area, maybe who is the owner of the land, who is the owner of the land. So if you do a search at the area, then it is good. When you go on the land, so we have dealt with the first about the ownership of land. That is the general aspect of it that I've looked at.
Right.
So now I want to go to maybe the processes you have to go to when you acquire, before you acquire the land. So having identified the particular land, whether it is a state land, whether it is a stool land, whether it is a family land, or whether it is an individual. You know, an individual, as I said, can buy the land from a stool. Or
right.
that we may get it. So having done that, you know, let me just quickly cap this in that if you are a foreigner, and I mean a foreigner is a non-Ghanaian, then you may not, if it's a stool who is giving the land, they cannot give it to you beyond 50 years. So that is what you must be very much aware that if you are practitioners or wherever you are, you cannot do that. So having done that, then we have to conduct a search at the Lands Commission to know whether or not maybe the kind of whose property it is. Then after that, you also have to, of course, go onto the land. If you go there and it's a virgin land, then we are good to go. But if you go and you see maybe a strip of sand, or you see that somebody has started a work on the farm, maybe he has maybe started a farming on the land, or there is something to indicate that somebody was there before, prior to you coming there, then you must ask further to us. Maybe the owner of the land, please, who is the land? Who is this property? Who is farming here? Who is this strip of sand for? Who is this person? Who is doing this? Who is doing that on the land? So that you will be rest assured. You may also go around. You may also go around and ask maybe the people who are farming, who are doing activities in the area, if they are building, who has given this land, how did you get this land, so that you will be rest assured. Because if you do not do that, and then there's any issue, then we can say that you have not acquired it in good faith. Once you know that there's somebody on the land and you have not actually taken the steps for you to inquire to see that the property has been done, to know who was who was on the land, then anybody who has gotten there first acquires a better title than you, so that later, even if the matter goes to court, it's not likely that you may win the case. So having considered that, then we also have to look at certain things like, sometimes people think that if you see somebody entering on your land and you do not protest, you can go and fetch water for the person. You can go and then also help and get builders to come and build the land. As soon as they finish building, then you come and say that, oh, this is my land. It is never done. It cannot be that way. You see that sometimes people will come and say that, oh, I'm a bricklayer, so let me help you lay the brick. They'll help you quickly. They will do it quickly, so that as soon as the building, you have put your last roof on it, you have painted it, then they say, no, the land belongs to me. Now, in Ghana, that thing cannot be done because we have a certain law, that is Land Development Protection of Purchasers Act, 1960, Act 2. That just says that once somebody has generally built on a particular land, then a third party, if you are the owner of the land, you cannot come and lay claim to it. At best, the court may look at it and pay you a lesser compensation. But as for the land, you yourself cannot come and claim it. So you have to generally
Kwamina, help me understand what you are saying. I have bought a parcel of land. Some individual from somewhere quickly comes to build on my parcel of land because he saw that the land was lying there idle for a while.
Yes.
So he quickly comes to put up a nice building on the land. Are you saying that at that moment when he has built his mansion on my land, he becomes the owner of the land and I lose my interest on the land?
No, not at all. So the catch word was that what I said earlier was when you genuinely build on the land. You see, okay. You go onto the land thinking that the land belongs to you. Maybe okay. Mr. Mensah sold the property to Mr. B, and then he also sold it to Mr. C. And when you entered into the land, you were not aware that anybody has been on the land. Then by the law that I mentioned, the Land Development Protection of the Purchasers Act, 1960, then the court will look at the circumstances so that then let's pay only compensation to you. But if you as a builder, you know that, or you should have been prudent to know that this land belongs to somebody, but you didn't take the genuine step, then it cannot be said that you've not done the necessary investigation. Then we can say that you have not acquired it genuinely. Then this one, even if you build a mansion or even build wherever it is, if it's worth 1 billion Ghana cedi, it's the person who was the original owner of the land who will lay claim to it. So the catch word is that when the person goes onto the land, he must have gone genuinely without knowing anything at all. So having done that, then mean that you have your land. So there are two things you have to look at. It. Once you go onto a land and somebody protests that this is my land, make sure that you do the necessary steps to make sure that you're able to get it resolved. You know, there are certain things that certain times we have that at lintel level, that when you build up to lintel level, then you cannot, the person cannot come forward. There's nothing like that. The word is that if you genuinely entered into the place and then you build, then we can say that you can have a claim to the land, but otherwise you cannot have a claim to it.
Okay, so as just quickly, if you can chip in this, as a purchaser of land, once I buy the land, assuming most of the time there are people outside of Ghana who identify lands here that they are interested in, and they get other people to buy the land for them, in anticipation that when they finally relocate to Ghana to come and settle, they'll start building on the land. Now, for such a person, what step must they take to make sure that someone else does not come onto the land to build on the land before they get to Ghana, so that they do not lose their land, as you have explained?
Okay, that's a very, very good question. As what I'll say that at least when you build a land, you must, even if you put a strip of sand or you do something that will show that there's somebody on the land, then it's like you have secured it. Now, I will now go into the process of the registration later, but in answering your questions, I will say that first you must at least show that somebody's on the land, because if it's a virgin land, there's nothing on it, and somebody also enters into it and genuinely builds on it, then you are only entitled to compensation. But if you put something on the land, then the person who is the next person who is building it must make sure that he takes steps to investigate properly who the owner of the land is. And if he fails to do that, then he must also forget about that land. If you go to court, even though it may take some time, but it's likely that you win your case.
Great. Okay. So, thank you.
Yes. So having finished issues about that, then we come to processes of maybe the document that may be given to you. You know, the document that may be given to you, it depends on what you want to do. So that, you know, we have an allocation. Sometimes when you buy a land, they will give you an allocation paper and maybe a size plan. Then it is prudent for you that you may go to you may go and then register it by maybe getting a lease or an assignment on it. You know, when you're talking about lease or assignment, it's nothing difficult, but looking at it that, let's say for example, they'll give you a land that you have to stay there on it for maybe 20 years. So that is the time so mean that I'll give you the land, stay on it for 20 years. So that becomes like a lease. But if I also have to give it to another person, I may sublease it to the person or I may assign it. Assignment is that you have lost, the person who is giving out the property has lost all his interests. We call it. Sorry about that. I think there was a little bit. Yeah, so that's because something like reversionary interest. So that once a sublease is that maybe a lease is always for a particular period of time. So it can be, when it comes to foreigners, they cannot get it more than 50 years. Ghana normally is 99 years. So that if you are a Ghanaian, 99 years, but a foreigner, you cannot be more than 50 years. So that is where you can get a lease. So that when you get a lease, if you are a Ghanaian, you get a lease for 99 years. Then if you can also sublease it to a person that maybe the person will also be on it for maybe 98 years or 98.999 years. Then you can give it, you can sublease it to somebody like that. But if you have to give all your interests in the land to any other person, as if you have a lease and you want to give all your interest to somebody, then absolutely they mean that once the person says if you're not coming back, we call it what an assignment. Then in that case, it means that you cannot have any interest at all, whatever it is. You get it. So you have to know that.
Yes. So what we need to understand basically is that when someone says, I have bought a parcel of land, they should know the duration for which they have acquired the land. Because a lot of time, and quite recently, I've had that situation pop up where someone says, oh, I bought land. Then later he realized that what he had bought was just a 20-year lease in respect of the land. So that is also very fundamental. Now, so before you go on, there are some quick questions that I think are necessary in respect of what we had discussed earlier, if we could just take a look at them. Someone is asking, if I buy 2 plots of land and build on one of them, will the other land be deemed as not possessed?
Will the other, I've not heard the last word, the other land be
deemed as not possessed? So he's bought 2 plots of land. He's secured one because he's built on that one, but the other one has not been built on. So he's asking, would he be deemed to have possessed the second one because he has built on the first plot of land?
Okay, you see, we call it if it's, you see, I just want to be technical here and be clear. So you can, in one area, you can buy 2 plots of land and they will be, one will be at what point, they will not be adjoining lands. They get it?
Right.
Yeah, they will not be adjoining lands. Or you can buy a plot of land and it will be an adjoining land. Adjoining land means that the both plots are what together.
Together, close together. Right.
So if so I think that's what you want to talk about, is that maybe it's an adjoining land.
Adjoining land, I think so.
So that as long as you build on one plot, you see, when it is about what, it may not necessarily be, it's a question of fact. Because if the 2 plots are clearly, you can see that there's a clear separation between the 2 of them, then you see, I can buy a plot of land which is an adjoining land. I may work somewhere, but when somebody comes to the other plots, you will not know that as even you may think that the land belongs to somebody else. Please, do you get it?
Yes.
And so that if it happens that way, then the person may think that maybe it belongs to maybe another person, or maybe it has not even been given out. Then in that case, when it comes there, then we can think that, okay, maybe he has acquired it in good faith. The only thing is that we have to know that he has to give the circumstance that the onus is on him to prove that the person, any later person who comes, the onus is on him to prove that he has acquired it genuinely. So that he will come and show that, okay, when I came, at least I came and acquired it genuinely. But the buying it adjoining land, that does not necessarily mean that building at one place is conclusive that you have secured the other place, especially if there's a clear demarcation between them.
Right. So you cannot go and say, didn't you see my other house? Didn't it prove to you that the other plot is also? So obviously, whilst you are securing the one plot and building on it, you have to take steps to secure the second plot as well.
Yeah, the other one. Right. Because thinking that maybe, it's a question of fact,
Right.
You know, always when people buy land, they will ask that, oh, they have prepared indenture for me. Indenture is, in law itself, is not anything so much. It's just like a term that people use around. But in law properly, it doesn't have any legal connotation. I'm saying that because, you know, the old times, they have what we call indents. You see, they will shift the document, they will shift the page a little, the words a little, so they have indented it. So that's why they call it indenture.
Okay.
Those are the old times that's the way that they do it. But indenture, you see, when they give you a document, you have to know whether is it a lease, is it a sublease, is it an assignment. That's what we are looking about, so that we have to look at it and see what actually they are giving you. So indenture is not a document per se, but you know, in Ghana we have a term that, oh, they have even prepared an indenture for me. So you have to ask yourself, which kind of document are they preparing for me? Is it for, as you rightly said, is it for a particular time? Is it for a particular duration of time? You know what some people do? they will know that maybe a land at a very prominent area, the lease is about 20 years. They will have exhausted about 15 years. Then if you left with 5 years,
5 years,
then they will quickly go and sell it to somebody at an outrageous price. The person who is also, you think that, oh, he's buying a good land at a very good price, but invariably they are selling to you only the 5 years remaining.
5 years.
So yes, so you have to understand that what I'm getting is not only when they think that they will take a document to high court or whichever court and they put some red stamp on it, means that the document is genuine. We have to look at it and see whether or not what actually was given to you by the person, so that if what is given to you itself is not what they intended, then invariably your indenture is of no effect. Then after that, you have to go and stamp it, and then also go and make sure that it is registered. It's a procedure that we have at the Lands Commission. So you have to go to the land valuation and they'll stamp the document for you, and then they call also a process called valuation. It's a process called you first stamp and then it will be registered for you. So there's a difference.
Kwamina.
Sorry about that.
Yeah.
So yeah, sorry about that. So there is a difference between the stamping and also the registration. The stamping is done at the land valuation. That just to show, normally when you just pay some small amount of money for the stamping, but the registration goes beyond that, and it's a whole lot process that they do at the Lands Commission over there. So invariably, if you want to get a proper lease, then what you have to do is that you have to make sure that you go, or if it's an assignment or whatever sublease you want to do, then you can also quickly go to the registrar and then they will do the process for you. So I think that is what we have to understand, that indenture per se, as we always keep on saying that I've gotten an indenture, itself does not give you any document. It's not any document, extraordinary document, but you have to know whether what is the agreement. You have to know, what are we asking about? What do I want? Do I want maybe a full duration of the time that is given to me, or is it that I want part of it? So that if you are very careful about it, and you must look through your documents very well, and when you sign, then we can say that okay, you are good to go. But otherwise, you may not get anything at the end of the day. Then we are looking at after that, then we look at it. Even if you have not registered your land, if you have not registered the land, if anybody acquires this later, we call somebody the first purchaser. We call some principles in law equity, the law of equity, and he has developed some principles that where the equities are equal, the first in time prevails, so that where I go to a particular land in the first place, and then I've not registered it by going to the Lands Commission to register it, but another person also comes to me, then we can say that because I came there first, then because I am first in time, it means that I have to get it. So that is what we call, there are certain principles that come in. There is another principle, is that equity aids the vigilance and not the indolent, so that you must go around and make sure that if anybody is coming onto your land, try to prevent the person from coming into the land. Don't wait until the person has actually finished building or is about to complete before you come and say that, oh, we thank God that the person has built a mansion for me, so I'm taking my families and everyone to enter into it. Then it's not likely that you get it, because in law you are considered as an indolent person.
Okay,
so,
Kwamina, on that point, someone has a question that I think will fit into what you have said, because it's something we had earlier discussed, and then you brought it up in discussing the equitable principle. Someone is asking, with respect to possession, would the building of pillars on my plot be enough to show that I have taken steps to possess it?
Yeah, yours is taken steps.
Yes, pillars per se is not, because usually pillars are normally built by the owners of the plots. From my understanding, most of the times they are the ones who put pillars over there, so that putting pillars there necessarily does not mean that you are the owner because invariably they are the ones, the owners of the land. They normally demarcate the plots, and when you go, they will tell you that these are the pillars, and so these are where you have to buy it. So this is the demarcation, or this is the very area that you are supposed to buy. So a pillar per se does not necessarily mean that you have secured the land.
Okay, someone is also asking, and I think this goes back to our previous discussion as well. What if I buy land, I travel outside and come to meet someone has finished constructing a building on it? I think this is what we had earlier discussed about if the person had genuinely purchased it, then obviously you might lose your interest if you have not done anything to secure the land before you had traveled. So I think that's is answered. So someone is asking, what if I have sand and blocks on the land?
Yes. Yes, so sand and block on the land is a very good something, so that when you come on the land and you see that somebody has, of course, the sand cannot be brought there on its own. The rocks also cannot be go there. So it puts you on the know that at least there was somebody on the land. Then the one who is coming on the new person who is coming on the land must make sure and ask, please, how did this land come onto the land? How did this sand come onto the land? How did it get there? So that if you are convinced about it, then you can continue and you can do whatever it is. But you must understand that, we have to understand that if somebody, a chief, for example, he gives you land and you buy it genuinely, and then you travel and you go somewhere and you come, the chief does not have the right to go and sell it to a third party. You get it? The chief does not have the right to go and sell it to any third party. So when you come, because you are not aware, at least you have an interest over there. So if the person goes to the chief and the chief even lies to the person that, oh, maybe these areas, this very area I've not given it out, then it means that in this circumstance, we cannot say that you are supposed to take further steps. So that's what I'm saying, that at least when you do something if you acquire the land, try a step as the lands commission, so that the person, if he makes certain inquiry at the lands commission, he can show that at least there is an attempt somewhere. Then it will put him on the note that he also have to do certain things. Let me quickly chip in this, that sometimes a chief will give you a plot of land, and then when a new chief comes, he will tell you that now I am the new person, new king, new law. So come and then pay some money to me. Please, you have to understand that you are not under any obligation to go and give any money to the new chief. But if you are kind enough or you're magnanimous enough, then you can go to the chief and say that, oh, because you have come, I want to give you something small. But the chief does not have any right whatsoever, because once a chief gives you a plot of land, even if it's disturbed, as long as he was a chief at the time that he gave you the land, it is your land. Nobody can come and challenge it later. So you have to understand that even if it's disturbed, does not mean that he has not given you the land. It is still a land that you have properly acquired.
All right. Okay, Kwamina, let's move on to our next discussion. Quickly, because you had touched on the bit about indenture, my next question is, what documentation do you require from the seller of the land when you are purchasing? Okay. A lot of time, people talk about site plan, and I have seen people rely on site plan as proof of their ownership to the land. Would that suffice?
No, you see, at least we have to know, that's the beginning will be what nature of land is it. So assuming that maybe it's a stool property. As for stools, they will give you an allocation note, and usually it is signed by the chief, the current chief, and also the principal, no, the elders of the elders. If it's a family, usually it is by the head of family and maybe the principal members. Then they will give you a certain document. That document alone itself is not a lease, because the list is perfect when you go and register it at the Lands Commission. So that you must know that it is not just when they just write something like that it is a list, therefore it becomes a list. You have to go ahead and go and register it at the Lands Commission. So that even if you don't register it, you cannot use it as in evidence in court. So that we have to understand that it is not just like they signing something for you or writing something. And it's good that you have asked this question, that a site plan itself does not necessarily mean that it is a genuine document. Just that it shows that you are maybe, if it's given to you first, it shows that you have been the one who they have given that area to first. And so that if there is any issue and maybe there are two people who are fighting over the land, then we can say that because you were the one who got there first, then you are the one who is supposed to get it. So the document that is supposed to give it to you, one, we have to know what are you doing. So if somebody is a stool and is giving you a land, you have to know the stool cannot give you the land forever. You have to give you, if you're a foreigner, at least 50 years. So that if you're a foreigner, then you can go to the Lands Commission and go and register it. Then we know that after the 50 years, then you can you may leave. Then you just quickly remind me about this issue about, because I'm to reversionary interest. If you build on a land, if you go into a lease, maybe for 50 years, if you build on it, after the end of the 50 years, you are an obligation to leave, unless you put in this that after you put in the agreement that maybe we call it renewal clause, that maybe after the 50 years, the owner of the land who has leased the property to you will have to renew the lease for you. But if the person does not renew it for you, if there is no such clause in the documents, then even if you have a mansion or even the whole of whatever it is on it, you cannot lay claim to it, because there is no reversionary interest, there is no renewal clause in it. So it's very important that if you want to secure a future and maybe the lease is about 30 years, you put a clause in it that after the 30 years, at least I can still come back. You will have to renew it for me for additional 30 years or whatever time, or maybe at a given rate. Then maybe we will agree that, okay, after that time, something can come to you.
Okay. So what you would require then would be the lease, not necessarily a site plan. Now, someone is asking, usually when you are purchasing land in Kumasi, they give you something called an allocation paper.
Yes.
Would that document be enough to secure your interests in the land?
Yes, you see, equitably, because we have two aspects of it, equitable and the legal aspect. The legal aspect is when you register it at the Lands Commission. The equitable aspect is when the chief gives you the land, but you have allocation. Allocation note is just to show that the chief recognizing that in so and so time, I've given this land to you. So that if the chief gives you the allocation note, it means that he does not have the power to give it to somebody else. And if you give it to somebody else or somebody comes onto your land, then we can say that, okay, I was there first. Then at least you have certain rights. But it is prudent that for you to secure your rights, you have to go to the Lands Commission to go and complete it by maybe the chief giving you that, okay, you stay on it for maybe so and so number of years, then that one becomes a lease to you.
Okay, so that means that the allocation paper plus the what's it called, the lease document is what you have to take to the Lands Commission to go and register, not only the allocation paper.
Usually, when you go to the Lands Commission, they will give you something like, they will require that you bring the allocation paper. You will also bring the site plan which is signed by a surveyor or anybody who has been authorized by the surveyor to sign. Then after that, they will come and tell you that they want the cadastre, because of the cadastre, then they will come and pick that one. And then there are certain things, then you go and stamp it. And after that, they will start the process of the registration for you. So it is a full registration that it's not anything, it's not about issue of legal, but it's just like their internal systems of registry. You go to the federal department, they will check this, they will check it, and they will put it in it. It's something which is supposed to be so simple, but quite often it takes a very long time to do it in Ghana. I'm talking about in practice.
Okay, all right. So there's a follow-up question. Someone is asking that usually there's a condition in the allocation paper giving the purchaser 2 years to build, or the land will be taken from them. The person is asking, is this legal? And can they take it from you after 2 years if you haven't built?
You know, there are certain decisions. So there are two varying schools of thought on this. There are certain cases when you went to the High Court, the High Court said that, those old times, the High Court said that because of those number of years, as long as you're not able to do it, you are not entitled to it. But nowadays, the courts are finding difficult to say that, no, I cannot give my 200,000 to a chief that I want to build a land, I want to get the land, and on 2 years I've not done it. So the chief is taking the land back, and then he was not giving me anything. So that's the different schools of thought that we have now. The old system around the 1960, 65 cases, they are very strict on that. But nowadays, the courts are not really allowing the landowners to go scot-free because, you know, in everything, the person has shown some consideration. And so at least you must take certain steps that you must show that, okay, maybe the person is not ready to build, because a lot of times people go through certain difficult times. I buy, maybe A buys land, and then he falls into hard times. And then because you are saying that simply because of that, you are taking back the land, it's not so proper. So the courts nowadays are not in so much agreement with that. But, you know, we apply old cases and new cases. So it's now something which is a little dicey. So I think that it depends on what the courts that day has gone through that day. So, but you have to be careful that at least you have to start something on the land. When you have to start something, even if you start molding blocks, it's mystified. I think they have to show something, but I'm not sure that now a court will say that, okay, the chief should just take it like that. But sometimes if you leave the plot for a very long time, then maybe the court might say that, okay, it's unreasonably long time, so maybe. But that one too, it may be very difficult. The court, I'm not sure, is likely to agree nowadays. But as I'm saying, we have differing judges or different cases on that. So I think it depends on the judge specific or a case specific matter.
Okay, great. So someone is also asking, based on the earlier discussion we had about the renewal clause, someone is asking, does it mean my building will belong to the chief after my lease expires? The person says this is scary then, because by the end of the leasehold, the purchaser would be at his or her pension. So then how do you make sure that after you have built on the land, you have purchased and built on the land does not go back to the chief after your lease has expired? I think maybe you can go by what you said earlier.
Yes, what I'm telling you that if there is a lease, we have to understand that it's not always that once you build on the land, it is going to spend a certain number of years until you agree with the chief or there is a lease prepared. Then there is a certain duration. Then after the duration, you see, because something surrender, you can, before the time expires, you may quickly go to the chief that I want to surrender my present terms, and then you will rebargain. So that is normally the practice, that you can go and call something surrender, then you can go and then ask that you rebargain. So usually that is the practice that we have normally around that. We call it. But if there's no renewal clause, as long as the time expires, then you are supposed to leave the place. But you may go and then renegotiate with the chief quickly before the term expires.
Okay. So just a quick one. I know you have gone into it. We still have a very limited time, but I just wanted you to go with us through the process again. So I have gone to see the seller. I have been given the document. We've signed the document for it. Now I go to the Lands Commission to go and register my interest in the land. Is that what you were saying earlier? And yes, then you were trying to distinguish between stamping and the registration.
Yes, so the first is the purchase. I buy the land. Then I know which kind of land I'm buying. Secondly, maybe I enter into some agreements. Maybe that's usually they call it indenture. Then you go after, they call it the so-called indenture, which can be this. Then you start the process of registering it, maybe at the Lands Commission. But you see, that's what I'm saying, that the non-registration at the Land Commission does not necessarily mean that you are not the owner of the land, or you are not the owner as of that time. Please, we must be very clear about that. If I finish building on a land, then I am presumed to be the owner of that land, because the law presumes that a person is the owner of what he has already occupied or is in possession of. So that's the presumption. So anybody who comes and says that the land is not yours, will have to challenge this later. But I'm just saying that the prudent thing is that you go and register it as at the Lands Commission. Maybe if they may give you a certain number of years anyway. But nothing prevents you that as long as you're able to build quickly, you may stay there for a long time. Usually, this is out of the way, but I will say that it's really prudent for you not to go and register, because if you go and register at the Lands Commission, then certain number of chiefs will have to agree that if you are a foreigner, 50 years, or if you are a Ghanaian, maybe 99 years. But if I go and buy buy land from somebody, usually I can be on the land for as long as I want to be on it. If I have not actually entered into a lease agreement, if
Okay. Just one other question before we bring our session to a close. Someone is asking, with regards to a land gifted to another person, what measures must I take to become a legal owner of such a land? So a gifted land.
Okay, that's a very brilliant question. The person is entitled to 1 cedi this evening. So can I tell the person that he owes me I owe him, or the person owes me 1 cedi, please? It's a very, very good question. You know, it's an aspect that I've not really considered is about gifts. You know, we have two different types of gifts. One is the customary gifts, and the other one is the statutory one. The customary one is the old system where somebody gives you a certain, maybe house or a plot of land or whatever it is. Usually what you have to do is that when they give it to you in that way, then we call something asida. Asida is a token. It can be anything, but you must necessarily give something. You take some witnesses, and then they will go and give asida to the person. Usually, the person who is giving the land will do it in the presence of certain number of people. Then you must know that those people, you always have to remember them that, okay, Mr. A, Mr. B, Mr. C was present when they were giving Mr. Y was giving the land. Then after that, you have to give asida. Asida may just be a certain small token to show that appreciation, but it is very important. Without giving asida, the courts are ready to say that the whole process is not complete according to customary law. For customary law, asida is very important. But the statutory one, we prepare some document. They call it deed of gift. So that that one is just a written one. After that, you go and register it at the Lands Commission, and then you go and stamp it at the Lands Commission, and then you can go and register it. Maybe they may do the various changes necessary, and then after that. So for you to secure it, if it's just like the normal customary one, for you to secure it, you have to give asida, and then you must at least show that asida is a tree word, meaning it's a gift or what. Asida is thank you, a form of thank you. So if the person gives you the land, or maybe gives you a land, then you have to maybe get some people to go and thank the person. Then that is the customary one. Then the statutory one, you may not necessarily have to go and give any asida, but that one, it is written and signed by both parties, and then you go to the registrar, the Lands Commission, and then you go and then do it.
Register.
So that is how it is. Yes, please.
Okay, great. I think that about answers our last question. We would take a minute, because this program is being sponsored by Eno Travels. We have a representative of Eno Travels who has just a few seconds to have a discussion with us. Then after that, we would allow questions from our listeners. People who are here would allow them to ask questions. by unmuting themselves, and then we'll take questions quickly for you to answer. We can wrap up our event for today. I know many of you have so many questions. Unfortunately, we can just take a few because we are running out of time. When discussing land, it's always a lengthy discussion because there are instances where one person will sell land to 2 people. It happens a lot. One grantor will sell land to about 3 or 4 people. And every time you go, someone will come and say, oh, the land is mine. Then you have to go back and he'll take you to another land. Then another person will come, the land is mine. So then in that situation, what do you do? So those are some of the questions, but we'll allow Endo Travels to have a brief talk with us for some few seconds. And then after that, we'll come back to you, Kwamina. So Endo Travels representative, if you are here, we are ready for you.
I'm here. Thank you very much for this opportunity. And it's very good to see a new face. I mean, we've always been seeing yourself and then the others. It's good to see a very new face today. I mean, Enos Travels has been in operation for about 10 years. Just that because they want to give its clients the maximum satisfaction, they've been doing a lot of underground research and underground tours. And for about 2 years now, they have been in operation, full operation. Now, the main services that Enos Travels offer to its clients cuts across education, employment, visits, tourism, family reunion, among others. So for the students who want to go abroad to further the education for their masters, even for the lawyers who want to do their masters, they can also contact Enos Travels. For families who want to travel together, go on a tour, go for a vacation, go for honeymoon, can also contact Enos Travels. And then we also have employment offers for people who want to travel either to Europe, to the United States, or to other countries in Africa or Australia. We also have services for them as well. And as you can see, these are some of our clients that we took. I mean, exactly a year ago, we were in Budapest having fun, having a tour that has been with us for a longer time. And then for next year, we have a lot of packages. Because of COVID, we couldn't operate this year, but then next year we have 2 or 3 packages that are coming our way. And then we are also planning to travel with one of Ghana's best rappers in the month of February. So those who want to surprise their loved ones after Valentine, we have an offer for you. So Enos Travels, taking you to the world and beyond. Thank you very much, Amma.
Thank you so much, Dennis. We can't wait to travel again next year. This year has been a tough year. Next year, we have to unwind, and we would be sure to contact Endo Travels when we are ready to go again.
Sure.
So thank you so much. Now we are almost done with our time, but we are open to take questions from the public. So if you have any question, please unmute yourself and then you can ask your question. If anyone has a question, they can do well to unmute. You can go ahead and unmute yourself and ask your question if you have any question.
All right, Amma. So, I mean, I've been following the discussion, and I must say that it's been very informative and educative. But my question is on possession. My first question is on possession, especially when I buy 4 plots of land. Do I need to wall all the 4 plots? Or, I mean, the 4 plots are adjoining line, I mean, in terms of buying an acre of land. But I build on one of them with my future plan that later in the future, I have plans of expanding or building mansions on the 3 lands which I've left. Is it the case that I need to wall off all the other 3 plots of land, or it will be treated that because there was just one person that bought the land, the 4 plots of land, building on one also protects the 3? And in terms of the possession, does anything that I do to change the face of land be deemed as possession or I need to erect structures on it to be deemed that I've protected my land? That's my first question.
Okay. So as we discussed earlier, if it's adjoining lands, you see, a person who is a stranger who comes onto the land, he that is not in a position to know that this whole area has been acquired by, may not be in a position necessarily to know that the whole area has been acquired by Mr. A. So that you have to make sure that when anybody comes there, he will be able to see that at least this area has been acquired by us, Mr. A. You see, even if you weed it, if you weed the whole area, at least when somebody comes, you will see that there's something there. So that if a third party comes in, the only thing that we have to know is that when a third party comes over there, he must be able to see that at least somebody's on the land. So that's the only catch word. So it's a question of facts. So if it's adjoining land, it may not really mean that you have to wall the whole place, but just do something. Even if you have to put, even if it's strip of sand somewhere or strategic places, so that if a stranger comes in, you'll be able to see that, oh, this plot is acquired by somebody, Mr. A or B, then at least to put it on notice. Otherwise, the general public will find it difficult to understand, to know that the whole place or maybe the whole acre has been bought by Mr. A or B. So it's more of a question of facts. And then the possession, so that's the issue, that you should not necessarily be that it should be by, you should wall it, but just make sure that the people who are coming there will know that at least that whole area is yours. Otherwise, it will be very difficult. Somebody who is a stranger may not necessarily know that that is the situation.
Okay, so as a follow-up to that question, okay, Roger has raised his hand. Roger, you can go ahead. I'll come back after you've asked your question.
Okay, please, if you're buying up from estate developers, how do you know that it's a genuine land?
How do you know it's what?
It's a genuine land from estate developers. I have a friend who bought a land from estate developers, and they were one of the estate developers, and he did spell on it, and later they collected the land from him.
Okay.
Please, I'm not hearing the question well.
So he wants to know, Kwamina, he wants to know if you are buying a land from an estate developer, how do you know that the land you are buying is the same land that they have documented to you?
Okay, usually they do site plan. Usually they do site plan for you to see that maybe this is the land. So it is prudent for you that sometimes you have to go with somebody who is well versed in surveying and things for him to do, because they will give you coordinates. Usually when they go there, they have some machine that they're able to show that, okay, this is the land, or this is the coordinate of the land that they are giving to you, or not. So it's more prudent for you that you go with somebody who has that kind of knowledge for you to do. But usually the individuals in the public may not necessarily know it. So it's very good for you to go for somebody who is versed in probably a surveyor, and then he will be able to help you out with that.
Okay, so Kwamina, as a follow-up to this site plan, who is supposed to go with the surveyor? Is it, so I'm going to buy land, is it the landowner or the seller who is supposed to give me a site plan, or I have to go there with my own surveyor to go and take the coordinates for a site plan?
You see, it works in different ways. It depends on what you want. Sometimes it's in practice. Sometimes the owner will say that, okay, this is the land, go for a surveyor, and let the surveyor come and do it for you. In certain situations, the owner had already gone, and then the whole area has been planned and everything, and is given to you. So it's more of a case specific. But the issue is that for you to know whether or not the specific land is being given to you is the real one, then maybe you may go with a surveyor, because otherwise it will be difficult for you to know the coordinates. They have some machine that they will be able to use to check and see whether the coordinate that is given to you, does it conform to what is really on the paper. But that is it. So it depends on the situation that you are doing. Please, I hope we get the question, please. I hope we get that.
Right.
So it depends. And it must be prepared by a registered, somebody who is a surveyor, or a director of surveyor, or somebody who, if it's authorized by somebody, not just anybody, any surveyor who can prepare that document for you. Because if you do not get a proper site plan, the courts are not ready to admit it in evidence in court. So it must be properly done by the director or somebody who has been authorized by him.
Okay, so this let me ask my own question, which has been a major concern to me. I'm sure a lot of people may or may not have experienced it, but might have heard it. I buy land from someone,
Yes.
then when I start developing it, I realize that someone else comes and says, "Oh, I also bought the land from that very same person." If I find myself in such a situation, what do I do?
Okay, you see, if somebody acquires the property before you go there, if somebody acquires the property before you go there, then the person becomes the first person to go there. So it becomes the first in time. Then the person who sold it to you later does not have the capacity to sell it to you again. For in law, because something Nemo that would not have it, you cannot give what you do not have. As long as you sell the plots to Mr. A, then Mr. A becomes the owner now. You cannot also sell it to a different person. You know, the only thing that you can do is you can cause the arrest of the person, the one who sold the law, because it's a criminal offense. It's both a criminal offense, and also, secondly, you can bring a civil action for recovery of that sum of money that illegally taken from you, together with costs, cost and maybe interest on it. So at best, that is what you may do. But as long as a person acquires the property first before you come there, then he is the first in time, and then you cannot be able to really do anything. The only thing you can do is to cause the arrest of the person, or either go and sue him, or do both at the same time. You can cause the arrest and also sue him in court for selling the land to you. It's illegal. It's illegal for him to do that.
So if does anyone else have any questions?
If it's a chief, then the chief will have to. The chief may give you a new land, but you can cause the arrest of the chief. It's a criminal offense. He doesn't have the right to sell it to a different person, because he cannot sell what he does not have.
Kwamina, traditionally, how can you arrest a chief who are going to live for in the next 50 years?
Oh yes, of course. You know, of course, that legally you can be arrested, but
I mean legally, but traditionally and practically, how can you go and say that you are the chief, you have sold the land to, and I'll arrest you? But my follow-up question is
on two occasions in court, I've seen that where they've actually arrested a chief and brought him. And that chief was actually distilled by Otunfo. So
okay, so my follow-up question, please, my follow-up question is that, practically where there's an ongoing litigation on a piece of land, or maybe you buy land, later in the course of your stay, one person comes to say that I've been granted judgment by the courts, and so I am the owner. They will sometimes bring writ of possessions, paste it on your wall. What rights do I have as a bona fide purchaser for that value? Because as at that time, I knew that the person who I was buying it from had title. That's the first action. That's the first question. And then the second aspect of the question is that sometimes you may get judgments which clearly states that if the person has developed.
On this point, I can't hear you, please. I think your mic is off.
Oh, so all the things that I've said, you didn't hear anything?
No, if the person has, that was the last thing you said. So
the next quick thing is that if the person, I don't know which ones that you heard, because I've asked. So, okay, if the person has a land and that somebody gets judgment, And the content of the judgment is that the person who's already developed the land should buy or should just compensate the new judgment holder with something small. And the aspect of the land which hasn't been developed at all, we have to enter into new negotiations with them. What if I've bought those lands as a bona fide purchaser without notice? Do I still have to pay the new person who have had the judgment?
No, it's if you the question will be, have you developed it? If you've developed it, then maybe the only thing that we can do is the compensation. But if it's not that way, and it's just a bare land, then you cannot be said to be a bona fide, because the original owner, the equities are equal now. So the first in time will have to prevail.
All right, and my second line of question was that after I've bought a land from somebody and then a new judgment comes declaring another person as the owner, what are my rights as a purchaser? Maybe I've developed my land over the period. I've lived there for like 5, 6, 7, 8, 10 years. Do I need to repay the new judgment, the person who holds the new judgment? Or because I've already, as at the time I was buying, that person was, say, a high court or a court of appeal judgment holder. What are my rights as a purchaser of a land whose judgment have declared another person as the owner?
Okay, you see, it depends on the matter. If the person who lost at the high court is your grantor, then it means that you cannot link them, because your grantor, as long as the tree itself is bad, then the fruit itself is also poisonous. As long as the tree itself is poisonous, the fruit will also deem to be poisonous. So if the title, your grantor is the one who lost at the high court, then you don't have any rights. But if it's not your grantor, but it's somebody else, then the person will also have to bring an action against you, or you may also bring an action against the person to challenge ownership of it. That means that we have to know about who was your grantor, or who is the owner of the land now. Then it will become issue of what the actual owners of the land, whether the person who gave it to you, is it the right person or not. Then it goes from there. So the issue now will depend on whether or not the person who lost, is your grantor. If it's your grantor, then of course your grantor who has nothing can also not give you nothing, cannot give you anything. And then, but if it's not your grantor,
but as at the time that he gave me the land, he was the rightful owner. It's just that later judgment has changed, or there has been a further declaration. So I was a bona fide purchaser for value, that I was buying from a rightful owner.
Oh yes. So as long as of the time that you are buying the plots, you acquired it from the right source, then whatever judgment is obtained against the person, you have already had your interest already. You see, we have to understand that when there is a judgment, the judgment is subject to the interest of any person who has a title to the land. I'm telling this example because if, for example, Mr. A has come to hire a house from me for maybe 20 years, rent a house from me or lease a house from me for 20 years, and then I, as the original owner, I'm the owner of the property, and maybe I have like 30 years. If somebody wants to execute judgment against me, he will have only the right for only the 20 years, but not the rest of the years, because I am the original owner. So the person who is the judgment is being executed against, we have to look at what interest has he got in the land. And if he is, so that's very material, what interest has he got in the land? And if that person has also sold it, and then a third party acquires it, then you have to go, the person who has gotten a judgment will have to go home with nothing. Because judgment per se does not necessarily mean that you have what, the land is yours. You have to go into execution. And if there's a superior interest in the land, then you may not be able to get anything at all.
I think just to add to what you are saying, because these are instances that keep coming up where after this new person has obtained the judgment, what they do is that they start writing to the people who are already in possession of the land, threatening that they will come and break down the buildings and all of that. A lot of the time, it's a way of getting them to come back to see them, to renegotiate the lease agreements and to recognize them as their new landowners. But oftentimes, even in the execution processes, the law requires that before they start the execution, they have to put all the other people who are in occupation of the land on notice. What I have come to realize is that sometimes most of the courts, when they are making orders in such cases, do make orders to secure the interest of the people who have already acquired the lands from their previous owners, who have now lost their interest in the land. So most of the judges now do make sure that in writing their judgments, they make sure that the new people who have been declared owners do recognize the interests that have already been given to the people who are in possession of the land, so that they do not go back to them and tell them that now we are new owners, we are coming to break down your buildings. So sometimes you have to, if you're a lawyer, for instance, and your client approaches you with such a scenario, you have to procure a copy of the judgment and look at the pronouncements that the judges have made in the judgments to be sure what your next step should be in such cases.
Okay. Yeah, I'm not getting your decision. For example, you see, if there's a stool land, okay, maybe a stool is declared to be the owner. Maybe there are two stools who are fighting over a land, and one is declared owner of the land. You get it?
Right.
As of the time that you acquired it, you have acquired it in good faith already, and you have built on it. So the thing is that it doesn't necessarily mean that the new stool that is coming will have to come and take over all those properties. No. It's not possible, because you have already acquired an interest over in the land. So there's nobody who can come and do it. But just that, as you are saying, you have to just atone tenancy. It's only when you challenge. It's only if a person challenges that they are not the right owners. Then if they lose, then once you challenge the owner, the title of your grantor, as soon as the person wins the case, then you must know that you have forfeited your interest in the property, as the procedure is. But if you do not challenge it, by just that maybe two people are fighting over it, and then one person wins, and you have a land, you have a building on it already, then the property is that maybe you can just go and then give them some token, but they cannot come and say that they are breaking down your house or whatever it is, just like that. It happens, I guess, it happens often in stools, when there are stool arguments or litigations over the rightful stools that who is entitled to a particular land. Then I think that's
Ato, this has been an interesting discussion. I think we've exceeded. We gave ourselves an hour.
Yeah. He has raised up the hand. I don't know whether maybe you can.
Oh, well, it's been long. Good evening, and thank you so much for the information and the education you've given to us, especially me. I'm very grateful. But I have a question. Assuming a land has been gifted to me by my father, and let's say currently there is litigation on the land, and after many years, I only have, let's say, the site plan with me. I don't have an indenture to the land. And after many years, the case is actually won, and I have the rights to build. What should I do, and what documents should I fight for, or who do I see to secure certain the needed documents, please? I don't know how to put a question, but I feel it's something that is troubling. Please, the land has been gifted to me. What should I do?
And there was litigation on the land.
Yes. And I only have
litigation between who? Is it litigation between your father and whoever bought the land from?
No. There are two stools to the land. The one who sold the land to, let's say, my dad, was disturbed, and a new chief has been is in place, and there is an argument. There is some form of confusion on the land, and now the judgment has been passed that those who bought the land from the first chief have the rights to the land, and let's say my dad is no more. What should I do?
Okay. So it's very, thank you so much. You see, when a stool gives you land, grants you land, even if the chief is the stooled, rightfully, even if the chief is stooled, as long as he was the chief at the time that he is giving the land to you, then you have acquired a good title. Then if it's a gift, then we have to know whether is it the customary gift or the deed, the statutory one as I mentioned, where the deed of transfer have been prepared for you. So if the customary one and you have already given us that, then you have already perfected your title already. You are already the owner of the land. If anything you want to do, maybe you want to go and register it as the owner of the land, maybe at the Lands Commission, that maybe as whatever you want, maybe you can say that maybe you can go and register that fact, that maybe the gift there have been a gift to you, and then you mentioned that maybe you have given us that. But if it's the deed of gift, then by all means it will have even gone to the Lands Commission already for it to be stamped, and then maybe the process of registration of the registration will have even continued. So I think that as long as the chief or whoever has a new person has, as long as the property has been gifted to you, you are the owner of the property. So you may do whatever you want to do. If you may build on it, so you may do whatever you want. You can even sell it to a different person. But when you're selling it, you recite those facts in on the document. That's what we call reciter. Maybe in the so-called indenture, or maybe whatever you want to do. The document you're going to give the person, you may recite those facts that maybe also and so date in the presence of Kofi Mensah and Mensah, my father gave me this plot of land, numbers also and so, and that I gave Asida maybe to so and so. So that's how it is.
Okay. All right.
Okay.
Thank you,
Jerry, I think yours is a peculiar case. You might want to see lawyer Kwamina Mensah later to discuss.
Oh, lawyer Amma.
To discuss how you
I'm sure I can always see Amma.
your situation will be best dealt with. So I don't know if there are any more questions from our listeners. We are about to wrap up, so if anyone else has a question, they can just wave at us and then ask their question. Other than that, we are about to wrap up. We gave ourselves an hour. We have exceeded our hour. Kwamina has been kind enough to indulge us for another 25 minutes after the hour, and we are very grateful that he's answered all the questions that we have. Someone is asking Kwamina for your number. If you can quickly type it on the side for the person in the chat section. Someone is asking for your number. If you can quickly drop it there for the person, we would be grateful. And so we are about to wrap up. Before I do, I've been told by the Office of September Bonds or something. Today is Jeffrey Mensah's birthday. So Jeffrey, we want to wish you a happy birthday. Unfortunately, I've not seen you in our chat today, but I'm sure you are listening to us on other platforms. So happy birthday, Jeffrey. We thank you all for tuning in and giving us your time. We hope you have learned a lot. There's an interesting discussion when it comes to land matters. Yesterday, someone wanted to know a bit about the procedure. Well, not procedure, the situation at the Lands Commission, Kwamina, because sometimes you do a search, one plot of land, you do a search, it will give you about two different people who are owners of that same plot of land. Or perhaps you could do a search today and then you get one person as the owner. Then the following month you do another search and another person's name pops up as the owner. These are a bit of discrepancies that sometimes you get from the Lands Commission. Someone was asking how you would deal with that. I don't know if you would have some sort of response to the person, but I was thinking that
it depends on dates. You see, it's Lands Commission is a statutory body, and so whatever they have stated is they are bound by it. So if they write something to you, and there is a date over there, whatever dates they have put over there is what you work with. So if you have any issue and there's any court matter, you have to call them. We subpoena them to come and answer the reasons why there is so much discrepancy. And a lot of things happen in Ghana, so a lot of things happen in Ghana. So
I mean, a lot of things happen. I was reading a case quite recently where one plot of land well, it wasn't it was about some many acres of land. When they did a search, I think it was about 20 acres of land. When they did the search over that same 20 acres of land, there were about 10 named owners of that 20 acres of land. I don't know if the owners owned particular plots or portions of the land, but it was quite surprising that a search could come.
That kind of thing that happened in the Lands Commission is a miracle. So we can really pray for them.
Exactly. Exactly. We wouldn't be able to answer, but hopefully the next time we have a discussion on land, we would bring someone from the Lands Commission to come and assist us.
Yeah, they will come and explain why they have those
responses when it comes to that. So, guys, we have exhausted our time. We have exceeded our time, actually. Thank you so much for indulging us. I see so many of my.
And I thank you all much. I always thank you for this, and I'm very grateful for the audience. And
yes, Kwamina, thank you so much for coming on board and for taking your time to educate us. We've learned a lot. I, for instance, have learned so many things. I mean, the law, we are always learning new things. So thank you so much. Guys, Kwamina has dropped his number in the chat box. So if you need him for anything, you can reach out to him. He's an amazing person, amazing old friend, very old friend. Me and him had an incident when we were little. I think one day I'll give you a call and remind you of that incident.
Oh yes.
Of that incident. So thank you so much for giving us your time, Kwamina.
Have a lovely evening, please, all of you.
Thank you so much. So guys, we've come to the end of our section. Thank you for tuning in. All right, bye.